Let's continue to drill in on that part of the story. Randy Kessler is a high-profile divorce lawyer who has handled cases for the likes of hip-hop artists Usher and T.I., boxer Evander Holyfield. He joins us live from the newsroom with some more perspective. So tell me how this process exactly works. We talked with Susan about this trust. Randy, is a trust for this type of estate smart because it kind of cuts down on that bickering, that back and forth, and all of those opportunists that Susan Roaston was talking about?
Well, that's exactly right. Let's first talk about the will. This is what we call a pour-over will, where everything goes into the trust because the will is publicly filed. Now we all see what the will says, and we're talking about it, but we don't know what the trust says, and that's exactly the purpose, is to keep that part of it private. You're right, there are opportunists. It may come out, but right now the trust is secret between the lawyers and the family. Okay, so
first of all, before we get into the next part of this process, you mentioned the lawyers. Lawyers are now the executors of this estate. Is that common? Have you ever been an executor as a lawyer?
I choose not to do that. Some lawyers do that, but you know, it's nice to have somebody that knows the law that's acting as an executor, because there are legal ramifications to their actions, and they do have these confidentiality ethical codes that they have to go by. So it's not a bad idea to have a lawyer as the executor. You know, you want someone you trust, and with that kind of money, you want someone you trust and who knows the law.
Sure, so it's not uncommon. This ex parte hearing situation, what is all that?
Well, as you know, ex parte means that you're the only one there. The other side is not there. There's only one side represented. What it really means is they needed a quick resolution because they had originally acted as if there was no will, and now they find out that there is a will. They wanted to reconcile those two vehicles, make sure that making Miss Jackson in charge of everything without a will was still okay now that they found a will, and apparently that's what the judge decided.
Okay, so if you have somebody as a guardian for your children in the will, is that signed, sealed, and delivered, or can it be debated? Can it be changed? I mean, can they go back and forth over this? Because as we know, children are not property in California.
Yeah, or anywhere, well, at least anywhere in the United States they're not property. But the bottom line is, the words they use in California and elsewhere is that guardian appointment is instructive, not directive. In other words, Michael Jackson instructed what his desire was, but he can't direct the court to do whatever he wants. So that's his instructions, that's his desire, that's his will, and now the court will look at it in conjunction with a determination of what's best for the children.
Is that something that happens for everybody? You don't have to be a high-profile person, you don't have to be Michael Jackson for that situation.
It's a good idea, because if there's a vacuum, what would the judge want to know? What would the decedent have wanted? You know, and it's interesting that Diana Ross is in there also. You don't have to ask Diana Ross's permission to be in there. It'd be interesting to know if she even knew she was in there. I imagine she probably did. But, you know, she doesn't have to accept the appointment. Things change. This was 5 years ago, so who knows? But it just is interesting to see what he wanted, and he loved his mother, wanted his mother to be in charge, and he thought if she couldn't, for whatever reason, Diana Ross would be next in line.
And Debbie wrote, even though he has basically nixed her from anything, she can come back if she so chooses.
Well, on the money, you know, she can't come back and get part of his estate as his ex-wife. And it's interesting that the will was signed right after the divorce. That's good practice. Had he not signed a new will after the divorce, then it would have been treated as if she had predeceased him. So she probably would not have gotten anything anyway. It's just good lawyering to say she gets nothing. But
for the kids?
For the kids, she can come back. Of course, she's got a lot of hurdles that she's put in front of herself by not visiting, not being a part of their lives. It'd be sort of hard to convince the judge that she was now interested again just for the best interests of the kids. But yes, she would have the right to come right back in and be right at the starting line.
So basically, we have a whole lot of stuff to look at in the days and the weeks and maybe even the months ahead.
Well, except I'm sure we do, and the family's got their fingers crossed that it won't get there.
Randy Kessler, high-profile divorce attorney here in Atlanta. Randy, great to see you. Thank you.
Thanks for having me, Nicole.
Fans are also